Bring in the jury, please. All right, I see all members of the jury are present. We're now ready to proceed. The jury is with the defense.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. I want to first thank you all for your service, your willingness to serve, and your attention with this matter. Mr. Sachs is an excellent attorney. He's made a great closing argument. A lot of drama, lining up all those shell casings, showing those 2 bullets. This case is a horrifying case. It's tragic, it's cold-blooded, but none of those things help you decide this case. You can think about Jacob all you want. And that's not going to help you decide this case unless you're going to use your emotions, which is what the law is going to tell you you shouldn't do and you can't do. Don't decide this case based on your emotions. That's what the state wants you to do because they are lacking the evidence. As Mr. Sachs told you, and I'll tell you, they don't have any evidence that he was at the scene of the crime, with the exception of Moises Reyes. They are relying on him. They can call him the icing, and they can say compare him to Jonathan, but the bottom line is he is the only person that says, and the only evidence they have, that Jonathan Santillan and Israel Vasquez committed this crime. Now, I want to shift to the assault because I agree. The assault is where we see motive. The December assault is where we know there's a problem. It didn't arise from that assault, as Mr. Reyes, Moises Reyes, would like for you to believe, or at least that's his testimony. That's what he testified under oath. He didn't have any problems with Sancho. He didn't know who Sancho was. That's what he told you. He drives by, and I believe he testified, and again, if I state something and your memory's different, go with your memory. But as I recall, he said, oh, I turned around because he followed me. Well, the car just pulled out, and it had two ways to go, and it happened to go in his direction, but to Mr. Reyes, this car was following him, and before long, he turned around and was facing that vehicle. But again, he didn't know anything. He didn't have any problems with anybody. That car backs its way to Old Stage Road. And he, Moises Reyes, the driver, continues to follow that car. And you know what happens. He drives down. That car stops. He gets out. And he threatens Juan Hernandez. Now, I asked Mr. Barefoot, Investigator Barefoot, I believe it was yesterday, what Juan told him. And Juan told him, when he was interviewed by Investigator Barefoot, that the man put a .45 caliber gun to his chest. Let me get it right. That one person pulled out a black in color gun, appeared to be a .45 caliber handgun, and stuck it to my chest and said, and asked if he was David. Now, the only person that we know, the person we know that did that is Moises Reyes. But he still is not willing to tell the truth about what happened that day in December. I believe he testified under oath, and you've heard about all his other statements that are inconsistent, but under oath, he told you, I got out and this guy came up and was being real mean to me, and I was like, maybe you better leave, something to that effect. He was just trying to calm things down. And his brother didn't like the way this guy was talking to him, so Trigger comes around and punches him. You know, yeah, I had a gun, but I didn't, you know, I just had it because I was afraid. And then, what Juan tells you though, what Juan told you from the stand was that, and the reason I asked the question to Detective Barefoot is because Juan testified he didn't see any guns. My recollection of Juan's testimony was he didn't remember seeing any guns that day. And Pablo's testimony was different in court than the statements he'd made to Investigator Barefoot. Because the statements he made to Investigator Barefoot was he saw Trigger with a gun. In both of his statements to Investigator Barefoot, he said Trigger had a gun. But again, from the witness stand, he wasn't that sure about the gun that Trigger had. Now, he obviously said Moises, the driver who came to their window, had a gun. Now, why would things change? I would suggest to you there's a real good reason. These folks are still afraid. They're still afraid of the Reyes. Moises, Pablo, that whole group. Pablo's out walking around. Pablo was in the courthouse. So they're not really wanting to say anything bad about Pablo. But they told you what happened, essentially what happened. And what happened was, and what's clear is Moises Reyes was the one with the gun, was the one demanding who's Sancho, and was ready to kill somebody. Now, that's not what Moises told you. And I believe Moises even said on the stand, I just showed the gun. I never pointed it. Again, he's had 2.5 years to get this story right and tell the truth, and he cannot do it. He cannot do it. He's unworthy of belief. Period. He cannot just admit simply that he pointed a gun at somebody's head. It's undisputed. He didn't remember, I don't think he remembered turning the car off either. Why turn the car off? If he's worried about him getting out, they could drive off and it didn't matter. And that's what they ended up doing, and it didn't matter. No, he was looking for Sancho. He had a score. And we don't know what that was because Moises has never owned up to what really was going on. Now, we heard some stuff from David Gonzalez as to there was an earlier problem with Casper, and there was stuff going on. So you know there was something going on before the assault. Now, the state, I would suggest, if you remember their evidence on the assault, it was very brief. They spent a lot of time on the homicide. Crime scene reconstruction, a lot of stuff that really does not help prove who committed this crime. But they did a lot of stuff, videos. But what did they give you on the assault? They called Agent Hill, introduced 5 shell casings he collected, and that was it. They didn't ask him where they got the shell casings from. They didn't ask him anything about what happened on the scene. I asked those questions. I asked the questions. They took pictures. They didn't offer any pictures either. I asked Agent Hill, where were these shell casings? Where were they in relation to this blood spot that he found? And he told you. And I think it's important that we clearly have 2 distinct areas where there's shell casings. One where the fight was, and another 15 so feet away. Now, again, the state didn't do anything to try to help explain, well, where were the vehicles? Where were the cars in relation to what happened? Where, all you know is there's shell casings laying around. But one's 3 feet away from the blood spot. That didn't come from distance. And that's likely the bullet that went in his foot. And I'll tell you why. If you think about the physical evidence, if you think about how a bullet goes straight down into your top of your ankle and lodges in the bottom of your foot, that's very likely a shot from close range, down, not from some distance. Why would the shell casings be so close and actually on the other side of where the victim was if the shooter was all over here? Moises said the shots came from over there by the truck. And then Israel fired some shots too. And the shots must have been Jonathan because I saw him with a gun. But the shell casings don't match up. Mr. Sachs grabbed that .45. And he used that to explain what Moises was testifying. That Moises, he didn't shoot anybody. He was holding that gun by the barrel and hitting him like a hammer. Now, I don't know about you guys, but am I going to grab a loaded gun, presumably ready to be fired, and point it at myself and use it as a hammer to hit somebody? No. The way I would suggest, common sense says, if you've got a gun in your hand, you're going to hit somebody with the end of that gun. And if you decide you want to shoot them or try to injure them to get them off of your friend, your brother, then you shoot them. And I would suggest that's what happened. That makes more sense than any other version there is. The way the bullet entered his foot, the placement of the shell casings, it all makes sense that Moises Reyes, the one person who's out there being the aggressor, who's pointing guns at people, threatening to kill them, I believe what Juan Hernandez testified was, he asked me if I was ready to die. This is the guy that says, I don't even know what was going on. I was just looking for Sancho. The guys said, yeah, hey, where's Sancho? So I was just like asking these guys, where's Sancho? And then they got all aggressive on me. That's what the state star witness wants you to believe. It's incredible. And it carries over. It carries over to the homicides. And you know, we've talked about this. He goes in and talks to the police, Moises. And again, he lies. He doesn't admit anything, just like Jonathan did. I'm not suggesting necessarily you should believe either one of them a great deal. They lied. They bulled their way through it. They gave up stories, changed stories. You know, but there is a distinct difference. There is a distinct difference between Jonathan's statement, and this is a statement the state offered. This is their evidence. Again, if you think about it, the fact witnesses they called, people that knew facts, not law enforcement that gathered evidence, but witnesses to some relevant activity, they all conflict with Moises Reyes' stories. So they put Jonathan's statement up here for you to hear. And they want you to say, you know, he's not believable. So don't believe him, believe our unbelievable witness, Moises. And so, yeah, the fact, so there is I would say there's a distinct difference between Jonathan's statement and Moises. First of all, Jonathan had one chance. You heard it, you saw it. It was one night. He didn't have his medication. It was late at night. He talks to Jerima and Barefoot. He talks to them some more. He gets frustrated with them. He asks for an attorney. And if you remember, there was a moment. You can just hear his mind clicking that he was trying to decide, am I going to tell what I know? Am I going to tell on Moises? And he says, F it, and he goes over and knocks on the door and asks them to come back. And the first thing he says is, can you protect me? And of course they had to give him his rights, but that was the most important thing. Now, I asked Investigator Barefoot, did Moises Reyes ever ask if he could be protected in any of his statements? Of course not. He doesn't need protecting. He's the people that people fear. Moises and his family are the people fear, not Jonathan and Israel. They are the bottom of the food chain. As Chief Johnson said, they're the scapegoats. And that's what Moises is doing, making them the scapegoats. Jonathan had one chance, and albeit he was not truthful for a lot of that statement. What you can take away, I suggest, from that statement is two things. Under a barrage of misstatements, by the police. We have DNA here. We have it on the floor. We have it on a chip bag. We have it on everything, prints, all that stuff. Under a barrage of all those statements to try to get a confession out of him, he wouldn't do it. He would not do it because he didn't commit this crime. And he told him that. I'm not going to confess to something I didn't do. His reluctance to give information was fear. Because every time they asked him that question, before he could say Moises, he's like, can y'all protect me? It was fear. Moises, so if the state wants you to compare that to Moises' testimony from the witness stand and say, this is That's not a comparison at all. He's had 2.5 years to get it right. He had 2.5 months in March of 2013 to tell the truth. He got his lawyer to set up this meeting, and he couldn't tell the truth. Wasn't even close. His whole story was different than what he testified to on the witness stand. As far as that day, he decided to say it was Jonathan and Israel who fired the guns out at the assault. And then Jonathan calls him up, says, I want to get some weed. And so he goes and picks them up. And they get in the car with this big duffel bag, and and he takes them to get weed, and they get out, and he hears shots. So he tells that story in March. And in that story, he talks about that he had a BB gun at the assault. A BB gun. No, I mean, come on. A BB gun? Why lie about a BB gun? Well, if you had a .45, you might not want to say you had a .45. And as long as you're going to lie, you might as well just say you had a BB gun, right? Because that's what he did. He could not admit that he had an actual firearm on the day of the assault. But he cleaned that up about a week later in that April 4th interview when he met again with Investigator Barefoot and told him, oh, it was a black .380. And of course he knew at that point that 45 shell casings were found. He admitted on the witness stand, might be the only thing he said that was truthful, he had all the information. He had Jonathan's statement. He had information about the case. He had all that information when he went into that March 25th interview. He had the benefit of all that, and he still couldn't tell the truth. And the state wants you to compare the January 15th interview of Jonathan to their witness, to their star witness. There's a lot of things that just, I think you'll go back in the jury room and just don't make sense. Mr. Sachs asked the question, why would Jonathan and Israel, Jonathan provided the weapons, gave the weapons to Moses to go commit this crime, and he goes and commits this crime, and he brings them back. Why would Jonathan and Israel keep them? I believe that was his question. Why would they keep them? Why wouldn't they get rid of them? Well, it's a good question, but the better question is, if they went and committed this crime and killed these people, why would they keep them? Why would they keep them? And if you think about it and listen to what he said, what Moises Reyes told you is that when he picked them up, and this was from the witness stand, when he picked them up, they had this big blue duffel bag, and they had gloves, and they had masks, and they got out to commit this, which finally, I mean, he's saying at least he knew they were going to try to scare somebody. So they have masks and guns and gloves, and they go in and shoot up the place. And while I'm on that point, because I think it's a good point, he says he drives up, gets out, walks over to the house while this is going on. And he tells you this story about Israel shooting the gun, I guess into the brick steps, but I don't know if there was any evidence of any bullets to the steps. But then they all go to the car. They're all going. Jonathan comes out of the house first. Then Israel. And they all run and get in this truck. Now, we have eyewitnesses. Chief Johnson talked about 60 eyewitnesses that saw everything that happened. You heard from several eyewitnesses. And I don't think there's any reason to not believe what they saw. They have no reason to lie. They saw one person run and get in the truck. One. Not three. Which Moises would say there were three. They saw one. And they would have seen more than one. Again, Moises Reyes is lying to protect himself, to get himself out of a murder charge, and whoever else was involved as well. But, so, why, back to the question, why did Jonathan and Israel keep the guns? Why did they put them in the attic? Why did they hide them? Why didn't they get rid of them? And that begs the question of this. So Moises Reyes says, they got back in the car, and I took them home, and we didn't really talk about what happened. And they got out, and I asked him, they get everything out? They got it all out. So were they smart enough to get rid of masks and gloves? Why would you get rid of all that stuff and keep the guns? Did the state, you hear any evidence? Did they found any gloves or masks, toboggans? Moises said Jonathan had a toboggan on or a mask on at the assault. Where are they? They're just toboggans. By themselves, they mean nothing. People can have a toboggan, ski mask kind of toboggan. None of those are there either. They're smart enough to get rid of those things, or dumb enough to get rid of those things and keep the murder weapons. The truth is, they didn't commit the crime. They didn't commit the murders. They got the guns back, and the people, Moises and whoever else committed this murder, took off with whatever paraphernalia they had. And you can presume it was guns and masks. But it does not make sense. His whole version of what happened makes no sense. Now the state wants you to, it's pretty clear. The state wants you to convict Jonathan based on the fact that he was in the attic with the guns. That is the only thing they've got. And I would suggest to you that's not enough. Not enough at all. The fact, guns kill people. We know that. These guns are the murder weapons. But the fact that he's in the attic with them does not mean he pulled the trigger. The fact that Israel is trying to get up in the attic does not mean they pulled the trigger. You cannot make that leap. They want you to make that leap, but it's too big of a leap. The burden of proof is on the state, as you know. So, in fact, I believe Mr. Sachs said the star witnesses are the guns. Well, if guns could talk, or if guns could only be fired by their owner, I think that's something you see in futuristic stuff. If you have a gun, you're the only one that can fire it. That's not the way it is. Yes, this was like a little place where they kept weapons, but I would suggest these weapons were used by other people in this group. They weren't just Jonathan and Israel's guns. The one thing that cannot be explained, one other thing, there's a lot, one other thing that cannot be explained by the state, by Moises Reyes. Why does he call Gimby Estrada, or Itzamar Estrada? Why does he call her on January 4th, the day into the night of the actual homicides, asking for his AK-47? Why does he do that? If you believe him, he didn't. He didn't have any reason to want his gun. Jonathan texted him. Let's talk about texting and phone calls. What evidence have you heard from the state that Jonathan ever called or texted him? There's no evidence at all. There's no evidence. Moises apparently gave them his phone numbers in the interview. Well, you don't need Jonathan's phone to figure out who's calling him or who's texting him or who he's texting. You don't need that. We have no evidence from any phone, any GPS tracking, anything that suggests that Jonathan Santillan was at the scene of the crime, or that he called Moises Reyes that day to say, come pick us up. It is clear that Moises Reyes called looking for his AK-47. He apparently felt the need to do something to these people. He's the one at the assault, pointing the guns. He's the one calling, looking for his AK-47. All that points to him. None of that suggests Jonathan. Jonathan's not doing those things. Jonathan's just at home. And he calls Jonathan and wants to use the guns. It's abundantly clear that there obviously is no evidence that Jonathan was at the scene of the crime from the standpoint of any physical evidence, any DNA, any fingerprints. But you know, there is, and Mr. Sachs basically tried to say, well, they wouldn't have found any of that stuff anyway, so don't consider that. But the truth is they did find a footprint on a door. And you can't just dismiss that as, well, it could have been anybody's footprint. People were walking around. This is on the door. This is the person that kicked in the door, presumably. And we have no evidence. And the agent that testified, although Mr. Sachs said, well, you know, it's just a footprint, right? No, she said it's like a fingerprint. I mean, they are that precise. You can see if they've cuts in the, I mean, you have to find the shoe to get a match. But we've got shoes. We've got shoes from Israel's house. We've got shoes from Jonathan's house. We have no match. Are they so smart that they got rid of their shoes too, but decided to keep the guns? No. No, they just did not commit this crime. The state has introduced rap lyrics, essentially what that was, from a notebook. And I would suggest that's sort of they're desperate. They don't have any evidence to link Jonathan to the crime scene or to prove that he committed any of these murders. So they say, we're going to let you read these lyrics and see how you like that. And I guarantee you, and I don't listen to rap, but there's a lot of kids out there that are writing rap lyrics, and they're just like those you saw in that notebook. They're all about violence, sex, drugs, guns, and that's what was in those notebooks. What was the date? Do you remember the date on the notebook? It's from 2011. And they want you to say that shows that he intended to commit these crimes. That shows his intent. That shows his motive. Doesn't show anything. It's a red herring. It is stuff that we all despised, I would assume. Nobody likes violence, drugs, sex, guns. But that's what rappers rap about. And that's what apparently people like to rap about. And that's what was in that notebook. And I would suggest to you that that is something, it is a desperate move to try to get you, again, to not like Jonathan. And I don't think they have any problems with that. I'm sure you don't like Jonathan. We're not here to decide if you like Jonathan or not, or think he's a good person. That's not an issue. But those lyrics prove nothing. They are from a year and a half before. And that's all you know. I would suggest there's one other thing that's important, and there's a lot of things that you may be thinking are important, and I would suggest there's a lot of holes in this state's case. And so the fact that I'm not mentioning it, I'm sure you're thinking of things that I'm not going to mention. But I'd like to point out the interview of Jonathan and what was said. One thing that I find to be extremely telling. Jonathan said twice, "Let me call Moises. Let me call him. I can get him to confess." Now, why would you say that if you were guilty? If I'm guilty, am I going to call an innocent person and potentially have it blow up in my face by them saying, let's just do a scenario. So I'm Jonathan, and the police decide, okay, let's give this a shot. And Jonathan calls and goes, hey, Moises, look, the police just came and searched my house. They didn't find the guns, but man, they're upset. Why did you do this? Man, you've really gotten people angry. Why did you do this? So what can Moises say? He could say, I ain't talking to you, click. Then, okay, we got nothing out of it. He could say, man, I didn't know who it was. I didn't mean to kill these innocent people. Well, then you have a confession. Or he could say, Jonathan, why are you calling me? You're the one, you and Israel went and did this. So there's basically three options, and one could blow up in his face. That's why you wouldn't ask for that option if you were innocent. You would not expect somebody to turn it around on you knowing that you're innocent. And that's what he was willing to do. He was willing to get Moises on the phone, and he believed he could get Moises to admit to committing this crime. And they decided not to do it. And it's a shame that sometimes investigations or investigators just get blinders on. But they decided, you know what? You could tell from the interview, they just thought he was going to confess. They just thought he was guilty. But the truth is, he didn't confess. He told them who did the crime. He tried to get them a way to help them prove who committed this crime, and they wouldn't do it. And there's no good explanation. I mean, Investigator Barefoot can say, well, he was, his age. Well, they weren't too worried about his age when they were in there pounding him with questions and with, it was going back and forth. You heard it. It was full of cuss words, but they weren't too worried about him being 15. So it doesn't really make sense that they were worried about him getting on a phone, a recorded call. You can record any cell phone call and see what Moises says. Have him call Moises, say, Moises, they came search the house, they didn't get the guns. What do you want me to do with them? Man, these guns are yours. You killed these people. You need to get rid of them. Something to that effect. See what Moises says. It'd been simple. They didn't do it. Jonathan asked for that opportunity, and you wouldn't have asked for that opportunity if you were guilty. It would only lead to more bad things if you were guilty. Now, I don't have a whole lot to say about the charges individually themselves. I think it's pretty clear. All these charges deal with identification. Who did the crime? The burglaries, all of that does come down to who did it. There's a conspiracy to commit murder, and there's other conspiracies to commit the burglary. And I just want to mention conspiracy to commit murder. As you will read in the instruction, the conspiracy is a conspiracy between Jonathan and Israel. It's not a conspiracy. They could have charged him with conspiracy to commit murder with Moises Reyes, but they didn't charge him with that. That's for another day. They didn't charge him with accessory after the fact for hiding the weapons. That's not for you to consider. So what they've charged him with, however, is actually committing the crime. And so the fact that he did some things that could be chargeable crimes, he's not charged with some of those things. He's charged with conspiring with Israel Vasquez. And that instruction is going to tell you that conspiracy is an agreement between two people. Well, we have no evidence of any, you really don't know anything about Israel or don't know anything about his role in anything other than he was near the attic and Moises says he was there and went to the Colonial Drive and that he was there. But any agreement would all come from Moises. You'd have to believe Moises' version to say that there was a conspiracy between Israel and Jonathan. This case does boil down to that, ladies and gentlemen. Yeah, the guns were used. That does not prove who used the guns. And that is their star witness, and that is not enough. Moises Reyes is not worth belief. He could not even tell the simple truth from the witness stand. He's not been able to tell the truth in his statements to police. He's not worthy of belief. Jonathan denied being at that scene under a heavy interrogation. He denied it. You may not believe much of what Jonathan said, and you may not even believe the denial. But that's not evidence that he did it. Mr. Sachs said, flip a coin, or flip. You can believe one over the other, or you can believe neither one of them. But neither one of those things gets you to guilty beyond a reasonable doubt. Proof beyond a reasonable doubt. You must be fully satisfied and entirely convinced that Jonathan Santillan went over there with those guns and shot those people. And there is so many inconsistencies in the only witness that puts him there, Moises Reyes. It does not make sense. It is not enough. Yes, we'd all like to have a resolution. We won't. We don't want to send a person that's not guilty to prison. We want the people who did this to be punished. We all want that. But don't make a decision today to get that result if you're not fully satisfied and entirely convinced. And I would suggest to you, ladies and gentlemen, Moises Reyes is not worthy of giving him that honor of the belief. And therefore, ladies and gentlemen, I ask you sincerely to return a verdict of not guilty on any charge relating to the homicide. Thank you.
Again, members of the jury, I'm getting ready to charge you on the law, read to you the law that you're going to apply to the facts that you find from the evidence that's been presented to you throughout the course of the trial. I'm going to give you a copy of this, so if you feel the burning desire or urge to take notes about what I'm saying, you're going to get a copy of this to use as you see fit during your deliberations. If you want to take notes, you can, but again, you're going to get a copy of it. Members of the jury, all the evidence has been presented. It's now your duty to decide from this evidence what the facts are. You must then apply the law which I'm about to give to you to those facts. It's absolutely necessary that you understand and apply the law as I give it to you and not as you think it is or as you might like it to be. This is important because justice requires that everyone tried for the same crime be treated in the same way and have the same law applied. In my discretion, you have been allowed to take notes in this case. When you begin your deliberations, you may use your notes to help refresh your memory as to what was said in court. I caution you, however, not to give your notes or the notes of any other jurors undue significance. While taking notes, a juror may fail to hear important portions of the testimony. Any notes taken by you are not considered evidence in this case. Your notes are not an official transcript of the trial. For that reason, you must remember that in your jury deliberations, your notes are not entitled to any greater weight than the individual recollections of the other jurors. The defendant has entered a plea of not guilty. The fact that the defendant has been indicted is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, the defendant is not required to prove the defendant's innocence. The defendant is presumed to be innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense arising out of some or all of the evidence that has been presented or the lack or insufficiency of the evidence as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. You are the sole judges of the believability of each witness. You must decide for yourselves whether to believe the testimony of any witness. You may believe all, any part, or none of a witness's testimony. In deciding whether to believe a witness, you should use the same tests of truthfulness that you use in your everyday lives. Among other things, these tests may include the opportunity of the witness to see, hear, know, or remember the facts or occurrences about which the witness testified, the manner and appearance of the witness, any interest, bias, prejudice, or partiality the witness may have, the apparent understanding and fairness of the witness, and whether the testimony is reasonable and whether the testimony is consistent with the other believable evidence in the case. You are the sole judges of the weight to be given to any evidence. If you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all the other believable evidence in the case. The defendant in this case has not testified. The law gives the defendant this privilege. This same law also assures the defendant that this decision not to testify creates no presumption against the defendant. Therefore, the silence of the defendant is not to influence your decision in any way. There are two types of evidence from which you may find the truth as to the facts of a case: direct and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain or a group of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all of the evidence in the case, and after weighing all the evidence, if you're not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. Proof of motive for the crime is permissible and often valuable, but not or never essential for conviction. If you're convinced beyond a reasonable doubt that the defendant committed the crime, the presence or absence of a motive is immaterial. Motive may be shown by facts surrounding the act if they support a reasonable inference of motive. When thus proved, motive becomes a circumstance to be considered by you. The absence of motive is equally a circumstance to be considered on the side of innocence. You may find that a witness is interested in the outcome of this trial. You may take the witness's interest into account in deciding whether to believe the witness. If you believe the testimony of the witness in whole or in part, you should treat what you believe the same as any other believable evidence. You may find that a witness was an accomplice in this case. An accomplice is a person who joins with another in the commission of a crime. The accomplice may take part in acts necessary to accomplish the crime, or may knowingly help or encourage another in the crime, either before or during its commission. The law requires an accomplice to have an interest in the outcome of this case. If you find that a witness was an accomplice, you should examine every part of the testimony of the witness with the greatest care and caution. After doing so, if you believe the testimony in whole or in part, you should treat what you believe the same as any other believable evidence. Photographs and diagrams were introduced into evidence in this case for the purpose of illustrating and explaining the testimony of witnesses. These photographs and diagrams may not be considered by you for any other purposes. Photographs and videos were introduced into evidence in this case for substantive purposes. These photographs and video may be considered by you as evidence of the facts they illustrate or show. If you find from the evidence that the defendant has admitted a fact relating to the crime charged in this case, then you should consider all of the circumstances under which it was made in determining whether it was a truthful admission and the weight that you will give to it. I instruct you that the state has the burden of proving the identity of the defendant as the perpetrator of the crime charged beyond a reasonable doubt. This means that you, the jury, must be satisfied beyond a reasonable doubt that the defendant was the perpetrator of the crime charged before you may return a verdict of guilty. In this case, you have heard evidence from witnesses who have testified as expert witnesses. An expert witness is permitted to testify in the form of an opinion in a field in which or where the witness purports to have specialized skill or knowledge. As I have instructed you, you are the sole judges of the credibility of each witness and the weight to be given to the testimony of each witness. In making this determination as to the testimony of an expert witness, you should consider, in addition to the other tests of credibility and weight, the witness's training, qualifications, and experience or lack thereof, the reasons, if any, given for the opinion, whether the opinion is supported by the facts that you find from the evidence, and whether the opinion is reasonable, and whether it is consistent with the other believable evidence in the case. You should consider the opinion of an expert witness, but you are not bound by it. In other words, you're not required to accept an expert witness's opinion to the exclusion of the facts and circumstances disclosed by other testimony. Evidence has been received tending to show that at an earlier time a witness made a statement which may conflict or be consistent with the testimony of the witness at this trial. You must not consider such an earlier statement as evidence of the truth of what was said at that earlier time because it was not made under oath at this trial. If you believe the earlier statement was made and that it conflicts or is consistent with the testimony of the witness at this trial, you may consider this and all other facts and circumstances bearing upon the witness's truthfulness in deciding whether you will believe or disbelieve the witness's testimony. Now, before I get into the substantive law that you're going to apply in this case, I want to take a minute to go over the verdict sheets with you. Shortly after you go to the jury room, you're going to receive this envelope, and inside this envelope there is a copy of the jury instructions that I'm reading to you right now. There is also a notepad and an ink pen for you to use as you see fit, and there will be these verdict sheets. Okay, I'm going to kind of go through them in the same order that I'm going to instruct you on. Okay, so there's 7 verdict forms in this case. Each verdict form, at the top of the form, roughly the top quarter of the page, has what we call the caption of the case. It lists who the parties are, it lists the jurisdiction. It has a number that's assigned by the clerk's office that tracks the file through the system, and it lists that it is a verdict. And then in the body of each form, it lists the options for a particular count or charge. And then at the very bottom of the form, it lists the date and a place for the foreperson to sign and print their name. In the body of the document, for example, this is the first one, and I put them in chronological order, and I'm going to instruct you in chronological order. But in this one, it's we, the jury, by unanimous verdict, find the defendant, Jonathan Santillan, to be, and there's 2 options, guilty of assault with a deadly weapon inflicting serious injury or not guilty. It is your duty to deliberate upon the evidence, determine what the facts are, apply the law that I'm giving to you now, and reach a verdict in this case as well as the other 6 that are going to be submitted to you. Your decision in this case is either guilty of assault with a deadly weapon inflicting serious injury or not guilty. Your verdict must be unanimous, and there's a place for you to have the foreperson put an X or a check mark or mark whatever it is. But that's for the assault matter. The next one is we, the jury, by unanimous verdict, find the defendant, Jonathan Santillan, to be, and there's 2 options on this one. This is guilty of first-degree burglary or not guilty. Again, it's your duty to determine which of those 2 options you select in that case. This third form is actually count 2 of another file number. It's kind of confusing, but I suspect that one of your members may be able to explain how that works. There is two options here. This is guilty of conspiracy to commit first-degree burglary or not guilty. The next file number has 3 counts in it, so there's 3 verdict sheets with one number, count 1, count 2, and count 3. This one is, we the jury by unanimous verdict find the defendant Jonathan Santillan to be, and this one has, there's 2 primary options, and then potentially, depending on what you select, there may be other options. It'll become clear, and I'm going to instruct you on it, but I want to go over it with you now. The first option is guilty of first-degree murder of Maria Saravia. And then there's language below that that reads, if you unanimously find the defendant to be guilty of first-degree murder, was it, and it's your duty to answer these two questions below on the basis of malice, premeditation, and deliberation, and or under the felony murder rule. Or the other option is not guilty. So just to be clear on this one, as on the next one, which is basically almost an identical form with the exception, this second form deals with Jose Flores. If you determine the defendant to be guilty of first-degree murder of Jose Flores in this case, or Maria Saravia in this case, you also have to tell us which theory or both theories, and your decision as to the theory has to be unanimous, if that makes sense. So, or not guilty. If you find not guilty, then select that. But if you select that the defendant's guilty of first-degree murder, you also have to tell us which theory you found, and your decision as to the theory must be unanimous. The next verdict form is 2 options. It says guilty of possession of a firearm with an altered serial number or not guilty. And the final one is guilty of conspiracy to commit first-degree murder or not guilty. And actually, I got this out of order, but the conspiracy will be, you'll be instructed on the conspiracy, and then the final offense that you'll be instructed on is the altered possession of a firearm with an altered serial number. And again, your duty is to deliberate upon the evidence and make a determination, a unanimous decision as to each verdict in each case. And as I say, you'll get those shortly after you get to the jury room. The defendant has been charged with assault with a deadly weapon inflicting serious injury upon Juan Hernandez. For you to find the defendant guilty of this offense, the state must prove 3 things beyond a reasonable doubt. First, that the defendant assaulted Juan Hernandez by intentionally shooting him in the ankle. Second, that the defendant used a deadly weapon. A deadly weapon is a weapon which is likely to cause death or serious bodily injury. A .45 caliber pistol is a deadly weapon. And third, that the defendant inflicted serious injury upon Juan Hernandez. A serious injury is a physical injury that causes great pain and suffering. For a defendant to be guilty of a crime, it is not necessary that the defendant do all the acts necessary to constitute the crime. If 2 or more persons join in a common purpose to commit assault with a deadly weapon inflicting serious injury, each of them, if actually or constructively present, is guilty of the crime and also guilty of any other crime committed by the other in the pursuance of the common purpose to commit assault with a deadly weapon inflicting serious injury, or as a natural or probable consequence thereof. If a defendant is not guilty of a crime merely because the defendant, a defendant is not guilty of a crime merely because the defendant is present at the scene, even though the defendant may silently approve of the crime or secretly intend to assist in its commission. To be guilty, the defendant must aid or actively encourage the person committing the crime or in some other way communicate to another person the defendant's intention to assist in its commission. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant acting either by himself or acting together with other persons intentionally shot Juan Hernandez with a .45 caliber handgun, thereby inflicting serious injury upon Juan Hernandez, it would be your duty to return a verdict of guilty. If you do not so find, or if you have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty on this offense. The defendant has been charged with first-degree burglary, which is breaking and entering in the nighttime of another person's occupied dwelling house without that person's consent and with the intent to commit murder. For you to find the defendant guilty of this offense, the state must prove 5 things beyond a reasonable doubt. First, that the defendant broke and entered a dwelling house. Kicking in a door would constitute a breaking. Walking into a house is an entering. Second, that the breaking and entering was during the nighttime. Third, that at the time of the breaking and entering, the dwelling house was occupied. Fourth, that the tenant did not consent to the breaking and entering. And fifth, that at the time of the breaking and entering, the defendant intended to commit murder within the dwelling house. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. You arrive at the intent of a person by such just and reasonable deductions from the circumstances proven as a reasonably prudent person would ordinarily draw therefrom. For a defendant to be guilty of a crime, it is not necessary that the defendant do all of the acts necessary to constitute the crime. If 2 or more persons join in a common person to commit burglary, each of them, if actually or constructively present, is guilty of the crime and also guilty of any other crime committed by the other in pursuance of the common purpose to commit burglary or as a natural or probable consequence thereof. If you find from the evidence beyond a reasonable doubt that on or about the alleged date that the defendant acting either by himself or acting together with other persons broke into and entered an occupied dwelling house without the tenant's consent during the nighttime and that at that time intended to commit murder therein, it would be your duty to return a verdict of guilty of first-degree burglary. If you do not so find, or if you have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty on that count. The defendant has been charged with feloniously conspiring to commit burglary. For you to find the defendant guilty of this offense, the state must prove 3 things beyond a reasonable doubt. First, that the defendant and Israel Vasquez entered into an agreement. Second, that the agreement was to commit burglary. Burglary is defined as a breaking and entering into an occupied dwelling house without the tenant's consent during the nighttime with the intent to commit murder therein. And third, that the defendant and Israel Vasquez intended that the agreement be carried out at the time that it was made. If you find from the evidence beyond a reasonable doubt that on or about the alleged date that the defendant agreed with Israel Vasquez to commit burglary and that the defendant and that person intended at the time the agreement was made that it would be carried out, it would be your duty to return a verdict of guilty to conspiracy to commit burglary. If you do not so find, or if you have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty on this count. The defendant has been charged with first-degree murder. Under the law and the evidence in this case, it is your duty to return one of the following verdicts: guilty of first-degree murder or not guilty. You may find the defendant guilty of first-degree murder either on the basis of malice, premeditation, and deliberation, or under the first-degree felony murder rule, or both. First-degree murder on the basis of malice, premeditation, and deliberation is the intentional and unlawful killing of a human being with malice and with premeditation and deliberation. First-degree murder under the first-degree felony murder rule is the killing of a human being in the perpetration of burglary with a deadly weapon. For you to find the defendant guilty of first-degree murder on the basis of malice, premeditation, and deliberation, the state must prove 5 things beyond a reasonable doubt. First, that the defendant intentionally and with malice killed the victim with a deadly weapon. If the defendant acted under the mistaken belief that the actual victim was the intended victim, the legal effect would be the same as if the defendant had harmed the intended victim. If the defendant intended to harm one person but instead harmed a different person, the legal effect would be the same as if the defendant had harmed the intended victim. If a killing if a killing of the intended person would be with malice, then the killing of a different person would also be with malice. Malice means not only hatred, ill will, or spite, as it is ordinarily understood. To be sure, that is malice. But it also means that condition of mind that prompts a person to take the life of another intentionally, or to intentionally inflict a wound with a deadly weapon upon another, which proximately results in his or her death without just cause, excuse, or justification. If the state proves beyond a reasonable doubt that the defendant intentionally killed the victim with a deadly weapon or intentionally inflicted a wound upon the victim with a deadly weapon that proximately caused the person's death, you may infer first that the killing was unlawful, and second that it was done with malice, but you're not compelled to do so. You may consider the inference along with all other facts and circumstances in determining whether the killing was unlawful and whether it was done with malice. A firearm is a deadly weapon. Second, the state must prove that the defendant's act was a proximate cause of the victim's death. A proximate cause is a real cause, a cause without which the victim's death would not have occurred, and one that a reasonably careful and prudent person could foresee would probably produce such injury or some similar injurious result. The defendant's act need not have been the only cause, nor the last or nearest cause. It is sufficient if it occurred with some other cause acting at the same time, which, in combination with, caused the death of the victim. Third, that the defendant intended to kill the victim. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. An intent to kill may be inferred from the nature of the assault, the manner in which it was made, the conduct of the parties, and other relevant circumstances. And fourth, that the defendant acted after premeditation. That is, that the defendant formed the intent to kill the victim over some period of time, however short, before the defendant acted. And fifth, that the defendant acted with deliberation, which means that the defendant acted while the defendant was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Neither premeditation nor deliberation is usually susceptible of direct proof. They may be proved by proof of circumstances from which they may be inferred, such as the lack of provocation by the victim, the conduct of the defendant before, during, and after the killing, the use of grossly excessive force, the infliction of lethal wounds after the victim is felled, the brutal or vicious circumstances of the killing, or the manner in which or means by which the killing was done. I further charge that for you to find the defendant guilty of first-degree murder under the first-degree felony murder rule, the state must prove four things beyond a reasonable doubt. First, that the defendant committed burglary. Burglary is defined as a breaking and entering into an occupied dwelling house without the tenant's consent during the nighttime with the intent to commit murder therein. Second, that while committing burglary, the defendant killed the victim with a deadly weapon. And third, that the defendant's act was a proximate cause of the victim's death. A proximate cause is a real cause, a cause without which the victim's death would not have occurred. And fourth, that the burglary was committed or attempted with the use of a deadly weapon. A deadly weapon is a weapon which is likely to cause death or serious bodily injury. A firearm is a deadly weapon. For a defendant to be guilty of a crime, it is not necessary that the defendant do all of the acts necessary to constitute the crime. If two or more persons join in a common purpose to commit murder, each of them, if actually or constructively present, is guilty of the crime and also guilty of any other crime committed by the other in pursuance of the common purpose to commit murder, or as a natural and probable consequence thereof. If you find from the evidence beyond a reasonable doubt that on or about the alleged date that the defendant, acting either by himself or acting together with Israel Vasquez, acted with malice, killed Maria Saravia with a deadly weapon, thereby proximately causing Maria Saravia's death, that the defendant intended to kill Maria Saravia, and that the defendant acted after premeditation and with deliberation, it would be your duty to return a verdict of guilty of first-degree murder on the basis of malice, premeditation, and deliberation. If you do not so find, or if you have a reasonable doubt as to one or more of these things, you would not return a verdict of guilty of first-degree murder on the basis of malice, premeditation, and deliberation. Whether or not you find the defendant guilty of first-degree murder of Maria Saravia on the basis of malice, premeditation, and deliberation, you will also consider whether the defendant is guilty of first-degree murder of Maria Saravia under the first-degree felony murder rule. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant, acting either by himself or acting together with other persons, broke into and entered an occupied dwelling house without the tenant's consent during the nighttime, and at that time intended to commit murder therein, and that while committing burglary, the defendant killed Maria Saravia, and that the defendant's act was a proximate cause of Maria Saravia's death, and that the defendant committed burglary with the use of a deadly weapon, it would be your duty to return a verdict of guilty of first-degree murder of Maria Saravia under the felony murder rule. If you do not find, or if you have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of first-degree murder of Maria Saravia under the felony murder rule. If you do not find the defendant guilty of first-degree murder of Maria Saravia on the basis of malice, premeditation, and deliberation, and if you do not find the defendant guilty of first-degree murder of Maria Saravia under the felony murder rule, it would be your duty to return a verdict of not guilty on the murder of Maria Saravia. The verdict form sets out first-degree murder both on the basis of malice, premeditation, and deliberation, and first-degree murder under the felony murder rule. In the event that you should find the defendant guilty of first-degree murder of Maria Saravia, please have your foreman or foreperson indicate whether you did so on the basis of malice, premeditation, and deliberation, or under the felony murder rule, or both. If you find from the evidence beyond a reasonable doubt that on or about the alleged date that the defendant, acting either by himself or acting together with Israel Vasquez, acting with malice, killed Jose Flores with a deadly weapon, thereby approximately causing Jose Flores' death, that the defendant intended to kill Jose Flores, and that the defendant acted after premeditation and with deliberation, it would be your duty to return a verdict of guilty of first-degree murder on the basis of malice, premeditation, and deliberation. If you do not so find, or if you have a reasonable doubt as to one or more of these things, you would not return a verdict of guilty of first-degree murder on the basis of malice, premeditation, and deliberation. Whether or not you find the defendant guilty of first-degree murder of Jose Flores on the basis of malice, premeditation, and deliberation, you will also consider whether the defendant is guilty of first-degree murder of Jose Flores under the first-degree felony murder rule. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant, acting either by himself or acting together with other persons, broke into and entered an occupied dwelling house with the tenant without the tenant's consent during the nighttime, and at that time intended to commit assault with a deadly weapon, inflicting serious injury or murder therein, and that while committing burglary the defendant killed Jose Flores, and that defendant's act was a proximate cause of Jose Flores' death, and that the defendant committed burglary with the use of a deadly weapon, it would be your duty to return a verdict of guilty of first-degree murder of Jose Flores under the felony murder rule. If you do not so find, or if you have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of first-degree murder of Jose Flores under the felony murder rule. If you do not find the defendant guilty of first-degree murder of Jose Flores on the basis of malice, premeditation, and deliberation, and if you do not find the defendant guilty of first-degree murder of Jose Flores under the felony murder rule, it would be your duty to return a verdict of not guilty on the murder of Jose Flores. The verdict form sets out first-degree murder both on the basis of malice, premeditation, and deliberation, and first-degree murder under the felony murder rule. In the event that you should find the defendant guilty of first-degree murder of Jose Flores, please have your foreman or foreperson indicate whether you do so or did so on the basis of malice, premeditation, and deliberation, or under the felony murder rule, or both. The defendant has been charged with feloniously conspiring to commit murder. For you to find the defendant guilty of this offense, the state must prove three things beyond a reasonable doubt. First, that the defendant and Israel Vasquez entered into an agreement. Second, that the agreement was murder. First-degree murder on the basis of malice, premeditation, and deliberation is the intentional and unlawful killing of a human being with malice and with premeditation and deliberation. And third, that the defendant and Israel Vasquez intended that the agreement be carried out at the time that it was made. If you find from the evidence beyond a reasonable doubt that on or about the alleged date that the defendant agreed with Israel Vasquez to commit murder, and that the defendant and that person intended at that time that the agreement was made that it would be carried out, it would be your duty to return a verdict of guilty. If you do not so find, or if you have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. The defendant has been charged with possessing a firearm with a serial number that has been altered and defaced. For you to find the defendant guilty of this offense, the state must prove four things beyond a reasonable doubt. First, that a Haskell .45 pistol was a firearm. Second, that the firearm's permanent serial number had been altered and defaced. Third, that the firearm's permanent serial number had been altered and defaced for the purpose of concealing and misrepresenting the identity of the firearm. And fourth, that the defendant possessed the firearm. Possession of an article may be either actual or constructive. A person has actual possession of an article if the person has it on the person, is aware of its presence, and either alone or together with others has both the power and intent to control its disposition or use. In this matter, the state does not contend that the defendant actually possessed the firearm. The state only contends that the firearm was constructively possessed by the defendant. A person has constructive possession of an article if the person does not have it on the person, but is aware of its presence and has either alone or together with others both the power and intent to control its disposition or use. A person's awareness of the presence of the article and the person's power and intent to control its disposition or use may be shown by direct evidence or may be inferred from the circumstances. If you find beyond a reasonable doubt that an article was found in close physical proximity to the defendant, that would be a circumstance from which together with other circumstances, you may infer that the defendant was aware of the presence of the article and had the power and intent to control its disposition or use. However, the defendant's physical proximity, if any, to the article does not by itself permit an inference that the defendant was aware of its presence or had the power or intent to control its disposition or use. Such an inference may be drawn only from this and other circumstances which you find from the evidence beyond a reasonable doubt. If you find from the evidence beyond a reasonable doubt that on or about the alleged date the Haskell .45 pistol was a firearm, that the defendant possessed the firearm, and that the firearm's permanent serial number had been altered and defaced for the purpose of concealing and misrepresenting the identity of the firearm, it would be your duty to return a verdict of guilty. If you do not so find, or if you have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. Now, members of the jury, you have heard the evidence and the arguments of counsel. If your recollection of the evidence differs from that of the attorneys, you are to rely solely upon your recollection. Your duty is to remember the evidence whether it has been called to your attention or not. You should consider all of the evidence, the arguments, the contentions, and the positions urged by the attorneys, and any other contention that arises from the evidence. The law requires the presiding judge to be impartial. You should not infer from anything that I have said or done that the evidence is to be believed or disbelieved, that a fact has been proved, or what your findings ought to be. It is your duty to find the facts and to render a verdict reflecting the truth. All 12 of you must agree to your verdicts in this matter. You cannot reach a verdict by majority vote. When you have agreed upon a unanimous verdict as to each charge, your forepersons should so indicate on the verdict forms. All right. So we are now at the point where the jurors are ready to go in. So the alternates, Ms. Coons and Ms. Just a minute. And you actually, I may just get you to step aside when they exit, and I'll give you further instructions. The rest of you folks, I want to give you some instructions and then some informal instructions. After you reach your jury room, the first order of business is to select a foreperson. You may begin your deliberations when the bailiff delivers the verdict forms to you. The foreperson should lead you in your deliberations, and when you have unanimously agreed upon a verdict as to each charge and you're ready to have them announced, the foreperson should record your verdict, sign and date the verdict form, and notify the bailiff by knocking on the jury room door. You will then be returned to the jury room and your verdicts will be announced. So before I release the 12 of you to go to begin, remember, you can only begin by selecting a foreperson. Don't deliberate until you get the envelope. That's kind of like the baton and the relay. Don't start until you get this. You'll get that shortly. Your cell phones must be turned off. Please make sure before you go in there that your phones are turned off. You cannot use your phones. You cannot have them on. If you need to make a phone call to check on the kids or do something with work, just tell us when you need to take a break, and you can stop your deliberations and take a break and go outside of the jury room to turn your phone on and use your phone. But we have to be very careful about that. Again, your verdict must be based exclusively on the evidence that we have given to you, and you find the facts from that evidence. You cannot rely on any other source. I have pretty much controlled the clock up to this point, so I'm going to let you tell me when you want to take a break, if you want to take a break. If you don't want to take a break, that's fine. I've got other stuff that I'm going to be dealing with, so I'll be here, but all you need to do is knock on the jury room door and let the bailiff know. I would prefer and ask that any time you have any communication with the bailiff, whether you want to take a 15-minute break starting now or in 10 minutes or whatever, or that you have any kind of question or anything of that, put it in writing and knock on the door and hand it out to the bailiff. All 12 of you must be present in the jury room to deliberate, and the jury room is the only place that you can deliberate. You cannot deliberate on breaks. You can't break up into groups and deliberate by committee. All 12 of you need to be at the table, literally and figuratively, to talk through the issues that have been presented to you. You do not need to notify us that you have successfully selected a foreperson. I'll deal with all that later, but and again, you will be allowed to take your notebooks with you into the jury room to refer to, and as I've already instructed you. But I think that's everything I needed to go over with you at this point. But remember, anything that you want or need from us question-wise or whatever, just put it in writing and I'll address it. So what I'm going to do at this time is ask the two alternates to step aside, and the other members of the jury, if you would go to the jury room and only select a foreperson. Don't deliberate until we send you the envelope. From the state.
There were only a couple of I guess oral typos, I guess you would kind of call that. One of which I don't think really makes that much of a difference.
Something was singular in here, and I made it plural.
But on page 4, when you dealt with the accomplice testimony, it reads, and again, this is why this may not matter, because they're getting an actual copy of the written one. So I'll kind of leave this up to the defendant whether or not any of this really makes any kind of difference. but it reads in the middle of that paragraph, the law considers an accomplice to have an interest in the outcome of the case. And I had reported that you said the law requires an accomplice to have an interest in the outcome of the case. I'm not really lodging an objection. I think that's actually to the defendant's benefit. It goes more towards what they argue, what they want, but wanted to bring that up in case they had any kind of objection or problem with that.
Do you have any, you want to be heard on that one?
No, Your Honor.
Do you want me to bring them out and re-instruct them on that?
No.
Okay.
The bigger one that I think they may want is when you got to the transferred intent part on the murder case on page 11.
Okay.
The last sentence of that reads, if a killing of the intended person would be with malice, then the killing of the different person would also be with malice. I had recorded and noted that when you said that, you said A, so that then the killing of a different person would also be with malice. That kind of broadens it. And so that's more against the defendant's interest, and so I wanted to make sure I brought that up. Again, they'll have the written one there, and they'll see it for themselves, and I could be wrong, but as I was listening and reading along with you, I noted that, and I was worried that I just don't want this coming back on the want of a preposition here.
The want of a nail?
Yeah, right.
I don't know that I can see really the difference.
Okay.
That I wouldn't necessarily ask for a re-instruction on that. I didn't catch that. So it was A.
I remember
different person
stumbling
instead of
over
B
something in
different.
that section.
Again, I'm okay with it, especially as long as the defendant's okay with it. But if they're asking for a re-instruction on that piece, I'm certainly okay with that to clear that
Are
up.
you asking
but-
for that at this point?
I'm not, Your Honor.
All right. In my discretion, I'm going to leave it as is. They're going to receive copies of it, and those are, I think, minor semantic issues.
Absolutely.
Anything else?
No, sir, thank you.
Mr. Cutler, did you have any?
I didn't catch this before, but I believe on the mandates, the instructions on the burglary, or maybe it's on felony murder,
All right, so are you talking about page 13 is the burglary?
yeah, if
Before
you
I
look
get-
at that one, it just mentions, it mentions burglary, I believe. Wait a minute, let me figure out where it was.
Middle of page, well,
The point I guess I was trying to make is I believe it's different. The mandate for Maria, says to commit the murder, intended to commit the murder therein. So that's the underlying felony. I believe with Jose, it says intended to commit assault with a deadly weapon,
it does say it.
inflicting serious injury or murder therein.
That's one I missed. It's dead in the middle of the paragraph on last page of 16. Do you want to be heard, Mr. Sachs?
No, sir, I'm trying to find it still.
Middle of page 16, the big paragraph, right in the middle of that big paragraph.
Got it, okay. No, sir, whatever y'all think is appropriate, it's fine with the state.
I don't know that it makes a difference, big picture. I mean, I think, again, this is not a case of whether it was an assault or murder. It's a case about who did this, and I don't think that would.
Are you asking for me to bring the jury in and recharge him?
I'm not. I'm just was pointing that out to the
Okay.
court and for
And
the
I missed
state,
it, and I
in case they-
apologize. I mean, this is one of the ones that we went back through yesterday. Does the state seek me to bring them back out and recharge him? And if I bring them back out, I would just redo the final mandate, and then I'd also do the other two that you pointed out. To be honest, if I'm going to bring them in, I'm going to do all of it.
I don't, and what I note is that it not only does it say have the assault charge on it, but it also says or murder therein. So you do also indicate the other felony that's under Maria's mandate. So you just kind of added something in there for Jose's. So no, I'm not asking that it be re-instructed.
All right. Are you okay with that going in as it is, or do you want me to give the jury a copy with that redacted? The assault language.
I'm okay.
Just let it go as it is?
As is.
Because I think this tracks exactly what I said. I assume that's what I read. I certainly read, I see it in here, and I assume that I read it. I don't remember.
That's how I caught it, as actually, when you said it.
Well, I'm gonna send them a copy of what I read.
Okay, so you'll send a copy with that part out, is that what you're saying?
No, with it in.
Okay.
I mean,
'Cause that's
I'm
what
gonna
you
send them
read.
a copy of what I read them to
Okay.
include assault. The copy I'm gonna give them is gonna include the assault.
All right.
If I bring them back out here and recharge them, I'll send them a copy of how I recharge them. So, I mean, so at this point, you're okay with me leaving the charge as it is and sending them a copy, including the language regarding the assault?
I am.
Okay. State okay with that?
Yes, sir.
All right. Otherwise, you okay with me sending in the verdict forms and letting them begin their deliberation?
Yes, Your Honor.
All right. All right. If you'll knock and let them know that they may begin their deliberations. Let me say a couple of remarks to you before you leave. First, you're formally at this time discharged as jurors in this case. Once they start deliberating, we can't allow you into the jury room or have any contact with them. But you got your bag back?
Yes.
Let me start by saying thank you very much for your service. This is, jury duty we know is an imposition. It's an inconvenience. It's very difficult for you to, put your life on hold and come in here to deal with us, particularly in a case that takes more than just a few days. This has been a longer case. It's not by any stretch the longest, but it's also a very difficult case to have to sit through, and we all appreciate the fact that you, as well as all the members of the jury, were very attentive. I've seen you take lots of notes and have, sat through it all, and for that we're very grateful that you have taken this very seriously. The rules technically no longer apply to you, but I'm going to ask you not to talk about this case, particularly to the media or anything like that, until after the case is over with. Once you hear that a verdict has been reached and this case is closed, or whatever that verdict may be, you may want to talk about it. In fact, sometimes people find it to be therapeutic to talk about cases that they have sat through, just to kind of, talk through it, because you've had to keep this bottled up inside. Now it might be good for you to talk about. So when the time comes, if you want to talk about the case, you can. If you don't want to talk about it, you don't have to. You have the absolute right to be left alone. And if anybody bothers you or pesters you about that, first just tell them you don't want to talk about it if you don't. If you do want to talk about it, please be very careful and mindful. Obviously, you're not deliberating, but be mindful of what you say and vocalizing your opinions about the case. Oftentimes the lawyers like to talk to you, and it's okay if you talk to them. These lawyers have tried other cases and will be trying more in the future, and the only way that we can learn is to ask jurors, including alternate jurors, what you liked about their presentation, what you didn't like, what you thought was strong, all those types of things. They're just seeking positive comments or feedback. So if the lawyers or their staff approach you and talk to you about it, that's likely what they're seeking from you. Again, you don't have to talk to them, but if you'd like to talk to them, you may. The clerk is going to send you a check in a few weeks, which is in no way a measure of the value of the service that you provided, and it's not designed to pay you back for your time, but it's hopefully will offset any expenses that you may have picked up participating with us. I don't have anything else for you other than a final thank you. I do want to excuse you at this point. I'll let the if you want to take your notes with you, you can. If you want to leave them in the book, we'll tear them out and throw them away. We can get that red badge back from you. That would be great. And I'll ask the sheriff to see you, out here shortly. But I see that she has a note. Okay. Let me go ahead and excuse these folks, and then I'm going to need to bring the jury back in briefly. But very well. I'm going to let y'all go. Can you assist them in any way that they need? And once they're squared away, we can bring the jury back in.
Yes, ma'am.
The jury handed out a note that I'll bring them back out, find out who the foreperson is, and send them on they want to go on a 15-minute break. So as soon as she gets them squared away, I'll go ahead and bring the jury back in. All right, welcome back. I see all 12 members of the jury are present. I've received your note. I'll get to that in just a minute. The first thing I need to do is for the foreperson to identify themselves for me. And your juror number 7. I'm going to address my comments to you from this point forward. You're sort of the spokesperson for the jury. What I'm going to do is, is ask you questions. If at any point in time you don't understand any question, whether it's now or sometime in the future that I ask, all you have to do is just get me to rephrase it or whatever. You all have asked for a 15-minute break. I certainly will give you that opportunity. It's now roughly 5 minutes till 3. Let me explain to you how this is going to work. We're going to release you just like we have every other time for the 15-minute break. And whenever the 15 minutes is up, if you want to do it in 13 minutes or you want to do it in 17 minutes, whatever, if you'll just knock on the door and let the bailiff know that you all 12 are present, she will verify, or he, depending on which bailiff it is out there, the bailiffs will verify that you're all back from the break, and then we'll tell you that, once they have verified it, you can then resume your deliberations. Just leave the notebook or notepads and stuff in the jury room while you're on break. I just need to remind you that you cannot deliberate while you're on break, and you cannot deliberate until all 12 of you are back. The bailiff has verified that you're all back, and then we'll tell you, once she counts and says there's all 12, you can start deliberating again. Otherwise, I have to bring you back into the courtroom, and there used to be a lot of back and forth. So what I'm going to do is release you with those cautions and just remind you the rules are in effect while you're on breaks. Don't deliberate, and return to the jury room to be counted in 15 minutes, and you can deliberate from that point forward. Everybody else will remain seated while the jury is excused. No. Let the record reflect that all members of the jury have left the courtroom. Was there anything on behalf of the state?
No, sir.
Anything on behalf of the defense?
No, Your Honor.
We'll be at ease, and in 15 minutes, we'll verify they're back. So we'll just be at ease.
Spirit Court stands at ease.